Welcome. Can anyone see me? Welcome to yet another Danish Tech Challenge webinar. My name is Christina and I am part of the Danish Tech Challenge team. Today you will get another sneak peek of the Danish Tech Challenge program. We have in previous webinars talked about what is Danish Tech Challenge, what is how we work with capital and business development and also product development. And today it's all about patent. Why are patents so important for you as a hardware startup? What about your tech or your software? Is it possible to get a patent? These are some of the questions that you will get answered here today. And with me today, I have Anders from ABBA. ABBA is our FutureBox and Danish Tech Challenge partner. Welcome, Anders. Just before we start, if you have any questions about during the presentations, please use the Q&A box, not the chat box, the Q&A box, and we will answer some of them during the presentation and the rest we will take afterwards. Thank you. Would you like to present yourself, Anders?
Yes, thank you. Good to see you all. My name is Anders.
Anders, you have unmuted yourself. There's no sound.
My name is Anders, and I am a patent attorney who's been working with ABBA since 2006, and I've been working with startup companies and have been with the Danish Tech Challenge for a few years, and then also for many years I've been helping out in the Venture Cup in Denmark. So I hope I can give you some good advice on how to proceed. I have not made an actual agenda for the talk today. I put up some topics that I want to talk about, and especially I want to focus on why are patents interesting for startup companies, and then also some details about what does it take to get a patent and some things related to this, for example, trade secrets, and also about the cost of patents. I put in here a picture of the latest winner of the competition, Pentalog, and I hope they can inspire you to take part in the Danish Tech Challenge and also to think about patenting. My first slide here is shows some numbers that were acquired or obtained from by this Davis research. It is some years ago, I know this, but it was a large amount of work they did to analyze the 500 biggest companies in the US to look at what is the value of these companies, where is the value. And this company, Davis, found that in the mid-70s, about 20% or less of the value of a company would be in what they call the intangible rights. That is patents, trademarks, designs, and other rights for that matter. And this number, this ratio of where is the value has been increasing since then. And in 2005, it was about 80%. And this is a good ballpark number to keep in mind that the value of an average company, 80% of this is in the IPR, that is patents especially. And this also means that can you help me with the control, Christina? Okay, good. That for companies that don't have any patents, there might not be any value in this. This is especially also interesting and important for startup companies. But for startup companies, it's also very important to keep the team in mind, the team behind the company in mind. That is, I've seen really good ideas lost because the team was not there to carry it through and make something out of it. And on the other hand, I've also seen what appears to have been really silly ideas turned into big fortunes because they had a good team. So patents and the team are really important. Especially the team is also extremely important in the Danish Tech Challenge context. This slide should remind you how to proceed in your daily work, in your daily life as a startup company. I put in some information about Pentalog again, and you may note that some of the words in my slides are printed in blue with underlining. That is, of course, because they're hyperlinked. Pentalog has this nice picture on their website, and they have an explanation of what they do. That is, they make a fully integrated locking system for bike. And that is what you want to keep in mind as a startup, especially a tech startup, is you want to solve a problem. That's the whole basis of the company normally. And with this in mind, you also have some ideas about how to solve this problem. And this is something you should work in your daily life. You should work with writing this down. That is, define the problem, write it down, and make a good definition of the problem. And then, of course, also especially important is how do we solve the problem? What does it actually take? And you can write down this in as many details as required for this, because this is what you can show to your patent attorney, and that will give you a much better value for money in the patent application. Of course, also you should keep in mind, is this commercially relevant at all? Because that's what it takes also to create a valuable company. This text box is something I copied from Pentalog's patent application. Pentalog actually filed a patent application before they joined the Danish Tech Challenge. And in a typical patent application, there is a small line of text stating what is the object of the patent application. And here for Pentalog, it is an object to provide an improved locking system for bicycles. And they also indicate some effects they want to obtain with this, to be that the lock should be more convenient, it should be more difficult to force it open, etc. And what you should keep in mind here is that with a patent protection, that you have a protection for a technical solution for an interesting problem, that is a commercially interesting problem. And because you have the problem, the protection, you can keep the competition away, and therefore you can charge a higher price for the solution compared to what the competitors can do. And this higher price is really important in a patent context, because this higher price should, first of all, be what should pay for your patent expenses. And also this should, of course, be what should make this company successful.
Anders, there is a question. Is copyright and branding of your product design and name as important as a product design medical patent?
Copyright is important, but a bit tricky. In Denmark, in Europe, the copyright starts existing once you publish your copyrighted work. And whereas in the US, you need to actually register the copyright. And this is not something that is extremely important for the company. With respect to the branding, this is also something that's very important, but it becomes more and more important at a later stage. The patent right is really important to ensure very early, whereas trademark protection becomes more and more valuable the larger the company is. I hope this answers the question.
I think it did.
Okay, I'll proceed with the next slides. There. This next slide is about a patent application I wrote for another startup company. They're called Motility Count, and this company works with providing tests for sperm cells with the basis that the value of a sperm test is larger if you know how many cells actually swim. That is, how many motile cells are found in the sperm sample. And the inventor Jakob came up with this idea that you can put the sample below a filter and allows the cells to swim up through the filter and look at the cells, or even collect the cells. So this is the text box is claim 6 of the granted patent, and it basically says how to do this. That is, apply the sample below the filter. There. And this detail about adding the sample below the filter is novel. That is the first requirement to get your patent through. That is, the invention you want to protect in a patent application must not have been described anywhere in the world before. So this detail about adding a sample below a filter is new. No one's done this before. The next task for your patent, oh, sorry, go back one. The next task for your patent attorney would be to convince the authorities that this invention or this novel idea is also non-obvious, or what we also call that it has an inventive step. And in this case, by adding the cells below the filter and only having the motile cells swim through the filter, we get a better separation of motile cells from non-motile cells. And therefore, the sample and the analysis result is more valuable than if you look at all of the cells in the sample. And therefore, the patent was granted and is now in force. And it's important to keep in mind that it may take only a very small detail to get a patent through. If you can argue that the novel feature you have is non-obvious, that no one has thought about this and why they have not thought about this, you can get your patent through. But of course, there are also areas where it might be a bit more tricky and some other things to think about. That is, the Danish Tech Challenge is, of course, a hardware startup competition. But even for hardware, it may be very common and very important that you have software operating with your hardware. In the top right corner, I put a small image from a software patent that was granted to Apple. That is a slide to unlock that you may remember. And the situation, oh, sorry, go back. Yeah. The situation is that in the US, everything is based very much on case law, and the law says simply that a patent can be granted for any new and useful process, machine, manufacture, or composition of matter. And the exceptions in the US include abstract ideas, that is software. And I have a lot of case law about how to deal with this. In contrast, in Europe, things are much more well-defined in the law. That is, patents shall be granted for any invention in all fields of technology with some exceptions. That is, certain inventions or certain technologies are not regarded as inventions, and certain inventions are simply ruled out from being patented. And these details about not being regarded as inventions include programs for computers and discoveries also, for that matter. Discoveries could, for example, be the small molecule that can be used to treat a cancer, whereas programs for computers obviously is the software. But this limitation about not being regarded as an invention is only related to the invention as such, meaning that if your program for the computer is integrated with a piece of hardware, then it is no longer software as such, and you can apply for the patent for this. For example, Apple's slide to unlock. So if you're working within a field where software or biotech or pharma might be relevant, it is a very good idea to talk to your patent consultant about how to deal with this.
Anders, we have a question. Universal
Yes.
robots and mobile industrial robots don't have many patents, and they are still powerhouses in their industry. I think there is very much 50-50 on whether to get a patent or not, especially at such an early stage. If a big company wants to take our design, they have the money to be able to crush is in a court.
Yes, but as a small company, you are better off having the option to get the patent. Without this option, they would crush you in any case, and it would cost much money for them. But the big companies actually do take patents and rights seriously. They must, because they can lose in court, and they can receive big fines if they don't follow the patents and other rights that are there. So even though certain companies may not require many patents, they can also protect themselves using, for example, trade secrets. And that's what my next slide is about. So let's proceed to that. It may be very relevant for you to consider if you have something that can actually just be kept as a secret instead of patenting this. I put in a picture from Coca-Cola. The Coca-Cola is typically mentioned when you talk about trade secrets. Everyone knows, of course, that the Coca-Cola recipe is secret. No one knows it. And therefore, Coca-Cola have this big museum with a vault where they keep the secret recipe. But on the other hand, if you look it up on Wikipedia, you can find the recipe. So if you want to work under trade secret protection, then you have to keep in mind that first of all, it is actually quite risky to do this, but anyone can do what you keep secret unless they have stolen it from you. If someone gets the same idea and does the same, you have nothing to do against them. It's also important to keep in mind that the secret must be kept safe and well described. That is, if you want to and need to go to court with this, you have to convince the court that you have actually the secret, and you have to have a description of what is the secret. A current example of this is that there's a case between Google and an ongoing case between Google and a former Google employee. He left Google with a large number of files, and he was actually found guilty in a US court and fined, I believe it was about $170 million to pay to Google. The other side of this is Uber, for whom he's now working, and there's a fight going on about who is going to pay Google, if it is Uber or this guy himself. So trade secrets can definitely be important, but there's some risk about this, and actually it may not be an option for many products. For example, if your product must be authorized to be sold, that is especially medicine, then there's zero chance that you can keep anything secret. It might also be the same for many other products where you need some sort of allowance to sell the products. This compares to the patenting, and patenting should in this context be considered to be a trade with society. That is, by disclosing your invention, you get the protection, and the protection will normally last up to 20 years. Some may consider this to be only 20 years, but for example, for software, 20 years of protection may be too much, and therefore software may not be that interesting to protect with a patent. It is quite costly to get good protection for your invention by patenting, but it should hopefully be worth it because you can get a higher price for protected products. I mentioned that that Coca-Cola is a typical example of a trade secret protected product. Google is also often mentioned in the context of trade secrets, but it is interesting to keep in mind that Google's search algorithm is actually patented. There's a granted US patent for the algorithm, and that describes exactly what Google do. But of course, how they have implemented this method that's patented is kept secret. We have no clue about how they actually do with this, and especially also the data they put into it. Because as we all know, Google is also mentioned in the context of valuable data, and that is something that that can also be very valuable to many companies. That is, if you're working somewhere where you collect a lot of data from a lot of users, that can be valuable to companies who can use this data. Possibly not the most interesting for startup companies, but it is something that can be kept in mind. And this is actually also something that can be relevant for universal robots. That is, how do they use these robots and what can they do and how many have they sold of these? Something that's kept secret, of course, and something that they can use to improve their next generation of robots. Next slide here. Something that's also very important to keep in mind is if you have the right to file a patent application for your invention, and this is especially relevant for startup companies because who got the idea to do what you do in a startup company? I put in a graph showing reported inventions by some of our local universities, that is DTU, University of Copenhagen, and our IT university. Many startup companies are formed based on ideas that come from universities. And if you are a master student, for example, at a university, the starting point will normally be that the student has the right to file a patent application for the invention made as a student. That is, unless another agreement exists. It's not uncommon that students are asked to sign contracts before doing their projects. On the other hand, if you're employed by a company or if you are a researcher at a university and you make an invention as part of your normal job, that is, if you're hired to do research and development at a company, or if you're hired to do research at a university, then the right to file the patent application will go to the university. But as you can see on the graph below, there are quite a few inventions that have been patented. There's about 40% or so of inventions reported are actually filed as patent applications, meaning that there are a lot of rights in existence to universities, and the universities are very keen to have these rights turned into a business by someone. So that can actually also be something that might be interesting for many companies, also in the Danish Tech Challenge context. For example, if you have been at a university or come from university. So with respect to when should you do what, it's also interesting to look at this timeline. Of course, the first point on the timeline is getting the idea to do something. And the last point on this should be going public with this, that is either informing the general public about the invention or actually starting selling your products. So things to remember is, of course, secure the ownership of the invention and make sure that you have the right to file the patent application. Once you have the idea, it's interesting to screen the market and see, is anyone else working with this? This is something you can do yourself. You don't need your patent attorney to do this. Likewise, monitoring the field is also something that you can do yourself. For the analysis of the patentability, you probably should involve an expert for this. And an interesting thing about forming a startup company is, I said before that it's important to file a patent application early, but it is actually also important to wait as long as you possibly can with filing this patent application. Because the longer you wait, for example, do you have proof of concept or do you have an actual prototype, the more valuable your patent application will be. It's a very good idea to have the patent application filed before you contact investors because they really like patent applications. So you have a piece of paper you can show to the investor and say, this is what is protected. And what you should absolutely not do is file a patent application after you go public with your invention. That will kill the patentability in the first place, and it will be a waste of time and money to file the patent application. And something to keep in mind with patenting is that a patent does not allow you to do anything you're not already allowed to do. That is, regardless if you like the patent system or not. Patents exist and you have to be aware of them. So you should also consider if you have what we call freedom to operate to sell your products. And it might be an idea to have an analysis done for the freedom to operate. And this is actually also something investors are really interested in, because no one wants to put a lot of money into something where they're not allowed to do anything. And of course, as soon as you have the idea, it is a good idea to contact your patent attorney, for example, us at ABBA. And even though it is a good idea to wait as long as you can, it is a very good idea to contact your patent attorney as early as possible. So that would be the first thing to do. I put in here a timeline for typical patenting processes, and I also included some numbers for the typical prices of this. The first thing you do, of course, contact ABBA, and then we will write a patent application for you. And I put in as a typical price for this something like 50 to 100,000 Danish kroner. This number is very much dependent on what is the invention, what field is it in, how complex is it, and how important is it also. So a patent application may actually be done for less than 50,000 kroner. Now, it may also cost more than 100,000 kroner, but this is a typical range. There will be official fees in the patent system. For example, you file your first patent application. 1 year later, you update this to file what we call a PCT application or an international application. There's a large fee for this one. And in the prosecution of a patent application, you will receive search reports from the authorities, and these have to be dealt with. So someone will have to consider what is in the search report, how damaging is it to the patentability. It's a standard situation that once a patent application is filed, your patent attorney will attempt to seek the broadest possible protection for the invention. And therefore, the reaction from the authority will normally be, no, you cannot have your patent. And then you start the negotiation with the authority to get the patent through. So once you have filed your PCT application, the PCT application will cover nearly all countries in the world. And after 30 months from the first application was filed, that is 2.5 years, this PCT application has to be filed in each country where you're interested in the protection. At this stage, you should hopefully have an investor interested in this, in your product and your project, and therefore you should be able to get some help with this investment, because the national phase can be extremely expensive if you need the protection in many countries. And keep in mind that I didn't put any official fees for this, but at the national phase there will be lots of official fees, something like maybe a third of this, and a large part of this is also translation into all the local languages. Once the application is in the countries, there will be further prosecution of it, and each step in a prosecution will cost money. Eventually, you will have the patent granted. I put in 5 to 8 years as a typical number from the starting point of 0 months. And having a European patent granted, as it is now, is also very expensive because you need to file many translations. So to summarize, it is very expensive to patent an invention, but hopefully it should be worth it in any case. Especially investors expect that you have patent protection. So don't hesitate to contact ABBA first of all, and don't hesitate to file patent applications. So a few words about ABBA. I am in ABBA, Denmark. We have now a number of offices in a range of countries. Our headquarters is located in Sweden, and we have offices also in Belgium and Switzerland. We have offices in China, all with local experts in the laws there. We're about 350 people now, and 130 of those are patent attorneys. We have some attorneys at law, very good at trademarks and designs, and we have other IP experts as well. And importantly, we are available on Skype for business for meetings. I put in a picture of our office in Copenhagen, but as it is now with these Corona times, we are pretty much locked down, but we are definitely available on meetings on Skype. So that's it for me. Any questions are of course welcome.
Yes, we have a few questions. There is one from what I see and hear, people are very split between getting and not getting a patent. Some investors think it is a waste of money, especially if you are a startup, but you could be spending it on developing, and it seems that other investors should use it as a box to tick for the valuation. What about that, Anders?
Well, what you want to achieve with patent protection is that you can keep the competition away from what you're doing. There's no startup is going to want to go to court with the patent right, of course. If you think patenting is expensive, going to court is much, much more expensive. So that's not what you want to do with the patent application. But in my impression, it is still by far the most common that the investor wants to see a patent application. This is also, of course, very much dependent on what field are you working in. If it is a tech field, then patenting is most likely interesting. You might have a piece of software that can be patented, but may not be relevant for patenting. You may also have some other knowledge that can be kept secret, and that might also be interesting to investors. But as for trade secrets, you should definitely consider, how do we keep this secret? What is the secret? And how do we make sure that no one runs away with the secret and steals it? So it is not necessarily clear-cut that patenting is the only way forward. But my impression of the starting point is investors want patent applications.
Thank you. We have another. Are there any grants, funds in Denmark that can help with financing a patent law and the application process?
Yes, there are grants. And I don't have an overview of all this, but there's something like Innovationsfonden and other organizations like this. Google this and find their websites and see what you can achieve. It's typical that you can get some support for having a search done to evaluate the patentability of your invention. And there might actually also be other options for getting support for filing patent application. I don't have the full overview of this here, but the options do exist. So my suggestion is to ask around, and especially Google is a good friend here.
Okay, thank you. We have two more questions. What about publishing your idea on a blockchain? Can that be of help if a startup doesn't have the funds enough to patent? What's your take on that?
My take is that be careful with publishing anything. You can talk about your idea and talk about what you want to achieve with the idea, but as soon as you start talking about how to achieve this, you're risking losing it, or losing the chance of getting patent protection. You mentioned blockchain. I'm not an expert in blockchains, but this is, of course, within software patenting. And a few years ago, there was a lot of talk about how blockchain patenting totally exploded after Bitcoin came out. I don't know how valuable these patents are or what can be obtained with this. but be careful with publishing any details about your ideas.
One more question. Are you allowed to develop on an existing patent?
Absolutely. That's the whole point of, or not the whole point, that's one important point about patenting, is that by getting the patent protection, you disclose your invention, allowing other people to work on improving the invention that's patented or that's sought patented. So you're definitely allowed to work on it, but you may not be allowed to sell your product if the other patent that you're starting from is in force. So definitely allowed, but may not be possible after all.
Thank you, Anders. That's what we have time for today. I have one thing, and I would also like to ask you about when you entered the Danish Tech Challenge as a startup. Is it not right that ABBA will start looking deeper at each startup and match them with different advisors with different kinds of expertise during the program? Yes.
The past years we have been handing out a piece of paper with some questions to file a reply to, in order for us at ABBA to identify who is the most relevant IP expert for you to talk to.
Okay. Thank you. We will send out today's presentation later on. And I can also say that we have received many applications for this year's Danish Tech Challenge. So don't wait to send in yours, just send it right away. And then we can start looking deeper into your application. If you have any questions about Danish Tech Challenge, the program and others, please give me a call or send me an email, and I will try to answer them, or I could get someone from the team to help you. Thank you for joining us today, and have a nice day.